second of our discrimination talks begins with another case on victimisation, but this time we're looking at a case where an employee suffered a disadvantage at work after having made a claim of sex discrimination. And what makes this case unusual is the fact that she claimed that she'd been victimised by her current employer because she'd brought a claim of sex discrimination against her previous employer. And the protection is cast widely enough to allow that to happen. It might seem a bit odd, but if there is a causal link, that's a valid claim. Keep on scratching your heads. Hopefully this next case will actually make everything clear.
Right, in Boabdea, apologies if I've pronounced that wrong, and Commerzbank, Ms. Boabdea formerly worked for Deutsche Bank. She brought sex discrimination and equal pay claims against the bank because she believed that she had received a lower bonus than some of her male colleagues. She also resigned over this issue, and a few months later she joined Commerzbank. During the recruitment process, Commerzbank asked Ms. Boabdea why she'd left her previous job, and she gave numerous reasons, saying that she wanted to work in a smaller team, but she never referred to the fact that she was taking them to tribunal for sex discrimination. She was worried that if she told Commerzbank this, they wouldn't take her on. A few weeks into her new role, the press ran an article headed "Ex-Deutsche Bank worker claims sex bias over lower bonus." It named Ms. Boabdea and mentioned that she was now employed at Commerzbank. Ms. Boabdea got wind of the article and warned her managers about it the following day. One day later, she was sacked.
Now, she claimed that she'd been unlawfully victimised. She said Commerzbank dismissed her because she was suing Deutsche Bank for discrimination. Commerzbank denied this. They said that the reason they sacked her was because she'd failed to tell them at the interview. In other words, that she'd failed to say that she was taking her previous employer to the tribunal. And they said that when the article then was published, this exposed them to what they called reputational risk. Now, the Employment Tribunal decided that Ms. Boabdea had done nothing wrong by not telling Commerzbank about her dispute with Deutsche Bank. They said that she didn't mislead them. She may not have given them entirely full answers, but that was not the same as being misleading or dishonest. And they were satisfied that her litigation against Deutsche Bank was simply not relevant to Commerzbank. Commerzbank shouldn't have sacked her when they found out that she'd claimed sex discrimination against their predecessor. Full stop.
Now, there are two lessons to be learned from this case. Firstly, the Employment Tribunal was critical of the bank in that none of the managers understood how the laws on victimisation worked. And this highlights that training your managers on discrimination in the workplace in all its forms is very important. There's no point having an equal opportunities policy if no one understands what it means.
We do provide this training, by the way, for managers. There is also a subsidiary lesson to be learned about the importance of asking the right questions at an interview. As the Employment Tribunal said, this is a quote, "When asked direct questions, she gave direct answers. Failure to answer questions that weren't actually asked doesn't amount to a lack of honesty." And we should add a third, which is beware of the knee-jerk reaction. They clearly reacted very spontaneously to seeing that article in the paper. In reality, there was precious little to suggest that her claim against Deutsche Bank would have affected Commerzbank's reputation in any way at all. After all, it's by no means the first time that a bank has been accused of sex discrimination. The decision to dismiss was linked to that claim, and no doubt her managers thought that as she had insufficient qualifying service to bring an unfair dismissal claim, that they could dismiss her with impunity. Well, of course, that was wrong.
So Commerzbank ended up paying a tidy sum for their knee-jerk reaction. The cost of getting it wrong in a discrimination claim can be high, given the potential for unlimited compensation, and especially when you're dealing with a banker.
Okay, so let's look at another case, this time on indirect sex discrimination. And this occurs where a policy is applied across the board, but it happens to disadvantage a particular protected group, for example, women. In HM Land Registry and Maglu, Miss Maglu was on a career break of 5 years, ending in March 2013. under the arrangement with the Land Registry, she could return at any time with reasonable notice. Now, the Land Registry then found that it needed to reduce headcount, and it created a voluntary severance scheme. Under the terms of that scheme, they decided to exclude anyone who was on a career break and wasn't due to return until after the 31st of March 2010. To make matters worse, they then misled Miss McGlue by telling her that she would be eligible for the voluntary severance scheme, but didn't tell her that this would only apply if she indicated an intention to return before the 31st of March 2010, which of course she might otherwise have done. So, her request to be considered for voluntary severance was rejected because she was on that long-term sabbatical. She raised a grievance saying that the policy amounted to indirect sex discrimination, and despite even that, she wasn't given any consideration under the voluntary severance scheme, and to rub yet more salt in the wound, that grievance took 7 months to process and then was rejected.
The Employment Tribunal decided that the policy of excluding those on a career break disadvantaged women as a group, as statistically it was far more likely that women would be on a longer career break than men. The Tribunal was also satisfied that this constituted indirect sex discrimination, because the Land Registry couldn't show that it was a proportionate way of meeting a legitimate business aim. It was an arbitrary decision which couldn't be justified. The Employment Tribunal awarded Ms McGlue £5,000 for aggravated damages, £12,000 for injury to feelings, and £71,710 compensation for monetary loss, essentially the payout that she should have received under the scheme, because it was clear that her application would have been successful. The Land Registry appealed against all 3 awards. They argued that there were no grounds for aggravated damages. They also claimed that the injury to feelings award was too high and that there should be no monetary loss award. They said that because Ms McGlue remained employed, her income would ultimately eclipse what she would have received under the severance scheme, so those earnings should be set off against what was essentially an enhanced redundancy payment.
So this also went to the EAT. Now, the appeal against the aggravated damages award, that was successful, and that was reduced to nil because there was no basis actually for finding that the Land Registry had acted in a high-handed, malicious, insulting or oppressive way, and that's the only circumstances in which an aggravated damages claim can be awarded. However, the other 2 appeals were unsuccessful. The AT were satisfied as far as the injury to feelings award is concerned, that she had indeed been acutely disappointed with the whole situation, that it had upset her greatly, she'd been misled, and of course her grievance that took 7 months to be considered was dealt with very shoddily too. So she was entitled to that. And most important of all, they decided that her award of £71,000 was also entirely proper. And they said this: a successful claimant has got to be placed financially in the position they would have been in if the discrimination hadn't taken place. Now, in this particular case, what would have happened is that she would have received that figure as her severance payment, her voluntary severance payment. And they said, yes, she could then have gone on to get another job. It would have been a windfall, if you like, but she could have carried on earning money, having taken the severance payment. So there was absolutely no requirement to set off her continuing income from the Land Registry against the payment of compensation that she received. So it's a very expensive reminder to employers that you've got to check the rules for determining who can and can't apply for voluntary severance if you have such a scheme. Make sure they're not indirectly discriminatory. She got over £83,000. Nice to see public money being so well spent, isn't it?
Let's now look at the developments of the last year when it comes to age discrimination, and we'll start by looking at 2 cases which included allegations by claimants that they'd been singled out for dismissal because of their age. If an employee who has been dismissed suspects that the real motive was their age, they can bring a claim for direct age discrimination. In Sherritt and Credit Suisse Securities, Mr. Sherritt, who was 55 years old at the time of his dismissal, worked as a research analyst for the company within the Equity Research Department. He specialised in analysing the value and cash flows of general retail businesses, and he held the position of managing director. In 2011, Mr. Malik, who was 35 years old and also employed by the company, was headhunted and threatened to resign. However, he decided to remain at Credit Suisse after being offered a promotion to director. And by a huge quirk of fate, very shortly after his promotion, a redundancy procedure began. Both Mr. Sherritt and Mr. Malik were placed at risk amongst other people. Mr. Sherritt received lower scores than Mr. Malik, and he was eventually made redundant. He brought claims of direct and indirect age discrimination in relation to his selection for redundancy and his dismissal.
Well, the tribunal found in his favour. In relation to the direct discrimination claim, they said that Credit Suisse had intended to dismiss Mr. Sherritt when Mr. Malik threatened to resign. They found that Credit Suisse had used the redundancy exercise as a vehicle to secure Mr. Sherritt's dismissal, that low scores had been given to him in order to achieve that aim. Unheard of, I'm sure. And the tribunal held that this was less favourable treatment compared obviously to Mr. Malik and indeed the others involved in the exercise, and they upheld his claim of direct discrimination. As it happens, having found direct discrimination, they didn't have to find indirect discrimination. In fact, the two are mutually exclusive. But they did comment on it, and they did comment particularly on the use of the criterion potential, hinting, I think, that they would have decided that that was a criterion which could have favoured younger people, could be construed as being against older people. However, the tribunal did find that there was still a 30% chance that Mr. Sherritt would still have been dismissed if they'd actually adopted a fair procedure, fair criteria, fair marking, and they ordered that compensation should be reduced by 30% because of that.
You may be wondering how the Employment Tribunal came to the decision that Credit Suisse had intended to dismiss Mr. Sherritt in order to retain Mr. Malik. Well, amazingly, there were emails that passed between managers within Credit Suisse that suggested that their medium-term plan was to retire Mr. Sherritt and replace him with a younger colleague. Mistake number one. Now, those emails were disclosable in the proceedings, and given that stated intention, it wouldn't have taken the tribunal much to assess that the redundancy exercise was a sham, designed to oust the older employee when they discovered that his younger protégé was about to leave to go to a competitor. So what's mistake number two? Well, deliberately accelerating the redundancy process and awarding Mr. Sherritt an unjustifiably low score to make sure he was selected. And mistake number three, well, not settling the claim sooner.
Okay, it's actually quite rare, although by no means unprecedented, to have that sort of very clear evidence in the disclosed documents. But just be aware that if somebody says something like that, it will come out. So, direct discrimination is usually far more subtle than that. Nobody usually admits, certainly not in emails or on paper, to that being the reason for the dismissal, even if it was the conscious reason. And for that reason, tribunals actually are entitled to do what we call drawing inferences from the initial facts. And if the tribunal finds that there is an inference of discrimination to be drawn on the face of it, that's when the burden shifts to the employer to actually prove the negative, to prove that there wasn't in fact any discrimination in the decision to dismiss. And this is where we come back to Ms. Scarth, the cleaner who was dismissed for taking the loo rolls, etc. Now, she brought basically two unrelated and separate claims. This was an age discrimination claim. She'd been told by her employer that they were going to reduce her hours from 40 hours per week to 10. She said this was age discrimination. And the reason she said that was because she said, on the face of it, I want you to draw that inference that this is age discrimination. There was nothing else. Nobody said because you're older or anything like that, not like the last case. But she said, draw that inference because my colleague who's exactly the same as me, also a cleaner. She's 30, I'm 70, and you've only asked me to reduce my hours. The tribunal then said, all right, well, that shifts the burden of proof to you, Atkins Gregory, to show that that wasn't influenced by age. They weren't able to do it. Now, it may or may not have been, but they weren't able to do it. And therefore, she actually succeeded, believe it or not, in getting £6,000 for age discrimination. So the message is simple. If you're contemplating making changes to people's terms and conditions of employment, you do have to do it across the board, do it consistently, or be able to show why you haven't. The employer here couldn't explain why only her hours were being proposed for reduction. She got £6,000, probably injury to feelings, compensation, but certainly enough to keep her in loo rolls for a while. So.
Now, one of the highlights of the year for me was to watch the sad demise of John McCririck's career with Channel 4. For non-racing fans, John McCririck was a TV horse racing pundit for Channel 4 for many, many years. And it would be fair to say that he was an unusual man. And for those of you who watched him on Celebrity Big Brother, he redefined the term misogynist. Now, I will, if I may, quote directly from the Telegraph's report of the case. Mr McCririck, 73, said he was sacked from his high-profile role on Channel 4 Racing by anonymous suits and skirts as part of a drive to hire younger faces. He was dropped in 2012 when the station unveiled a new presenting team headed by Claire Balding, aged 42. He'd worked for the channel since it started covering racing in 1984, but a central London employment tribunal ruled against him. In its judgment, the tribunal said this: all the evidence is that Mr McCririck's pantomime persona, as demonstrated on the celebrity television appearances, and his persona when appearing on Channel 4 Racing, together with his self-described bigoted and male chauvinist views, were clearly unpalatable to a wider potential audience. The tribunal is satisfied that the respondent had the legitimate aim of attracting a wider audience to horse racing. Mr McCririck's response was suitably understated.
Right. This wasn't my idea. After such a landmark judicial verdict, my failed legal action ensures that anonymous suits and skirts who control the media, numerous other businesses and the public sector will now enjoy complete freedom to replace older employees, whatever their unimpaired ability and merit. I have let them all down, along with my wife, the booby.
Magnanimous in defeat. Perhaps this explains why Mr Thomas Linden QC told the Employment Tribunal that a survey suggested that McCririck was highly unpopular with viewers, and then made the following closing submission. Even without that data, it's a reasonable assumption, isn't it, that the claimant's profile, whether that is in his reality television programmes or in racing broadcasting, was off-putting to many. Clearly, he gelled well with him. Now, what's most galling to us is that Mr Linden would have been paid handsomely to stick the boot into McCririck when, well, we would certainly all have gladly done it for nothing.
So we now turn to the case of Asoba and the Chief Constable of the Hertfordshire Constabulary, where the Constabulary successfully rebutted a claim of age discrimination by relying on its own incompetence. Absolutely true. The Hertfordshire Police Force had to make redundancies to reduce a budget gap of £36 million. Mr Asoba had 30 years service and would shortly be eligible to retire on a full pension, and he was generally regarded as a star. Now, a Miss Pritchard, who was the officer charged with the responsibility to reduce the headcount, was responsible for drawing up a matrix of skills to test the qualities of the officers in the redundancy selection pool. Mr Asoba scored less than the others, so he was selected for redundancy. He argued that this was deliberate manipulation to make sure that he would score less than his colleagues, and that the reason for this was his age, connected obviously to his eligibility for retirement on a full police pension. So he presented a tribunal claim and argued that he'd been directly discriminated against because of his age. He also claimed straightforward unfair dismissal as well.
Under cross-examination, Ms. Pritchard was shown to have made errors in constructing the redundancy selection matrix and in applying the points, and she fully accepted this. The tribunal decided that the matrix she had devised and its subsequent implementation at all stages was shambolic and to some degree incompetent. However, although severely critical of her approach, the tribunal accepted that she was an honest witness who had admitted to the errors in the process. The tribunal didn't believe that she undertook the process with the object of selecting Mr. Asoba because of his age. Mr. Asoba was successful in his unfair dismissal complaint, which was a given really when one considers that it was accepted by all that the process was flawed. But his claim was far beyond the cap on compensation in unfair dismissal cases because of his pension loss. So he appealed against the decision on direct age discrimination.
Well, the EAT dismissed his appeal. They said it was hard to see what more Ms. Pritchard could have said, given the substantial battering she got in cross-examination. She'd done what she thought was right in accordance with the employer's policy, but she had to accept that she'd made huge errors in the way she'd applied it. And there may simply be cases where there isn't actually anything more than a witness can say, but I got it wrong and I accept responsibility. This was one of them. So whilst finding that the selection process was shambolic, tribunal's word, they also accepted her account that she'd acted honestly and she didn't have any ulterior motive of discriminating because of Mr. Asoba's age. So his appeal failed. Now, you might think it's a bit ironic that a get-out-of-jail card for a police force was honest gov, I got it wrong, but the open admission of an error in this case highlights some practical points. A direct age discrimination, in order to succeed, has to actually show that the less favourable treatment did occur because of age. So treating somebody unfairly or unreasonably doesn't automatically mean that there's been discrimination as well. He won his unfair dismissal claim, but he lost his discrimination claim.
Okay, now we're going to look at the issue of enhanced redundancy schemes and their inherent dangers. Many of these enhanced schemes use age as a differentiating factor when determining the sum payable to an employee upon redundancy. If they're modelled on the statutory scheme, which also uses age and length of service when calculating the amount, the legislation specifically directs that this will not amount to discrimination. So, for example, if the employer used the standard formula of age and length of service to calculate the number of weeks paid due, but disapplied the statutory cap on the level of a week's pay, that would probably be okay. But redundancy schemes that are not modelled on the statutory scheme must be objectively justified if they're to avoid being age discriminatory. So,
this case, Odar and Baxter Deutschland, is a European Court of Justice decision which looked at the operation of a compensation scheme, redundancy compensation scheme, which applied a special formula to taper the redundancy pay of employees who were aged over 54. And the formula for calculating their redundancy payments was actually based on age, length of service and pay, but crucially also it took into account the earliest date on which an employee could take a state pension, so that those over 54 had their redundancy reduced the closer they got to the state pension age of 65. Now, there's a further complication in this case because Dr. Odar was also severely disabled, and under German law, he was entitled to a pension for severely disabled people at age 60, in addition to the normal pension at 65. So when he was made redundant, he received a lower redundancy payment because he was aged over 54 and he was going to be entitled to a pension at age 60. Well, what they decided was that there was no finding of unlawful age discrimination because it was actually a legitimate aim to protect the financial position of younger workers as opposed to older ones and to have this differential in relation to the scheme for people generally. But what the ECJ did find was that the policy was indirectly discriminatory against disabled people. It clearly affected Dr. Odar and severely disabled colleagues, because they were entitled to that state pension at a younger age. They received less redundancy compensation than non-disabled employees, and that couldn't be objectively justified. So it's a warning that if employers are able to justify schemes even in the context of age discrimination, which actually is not impossible, the rules are reasonably generous on that, it won't necessarily preclude claims on the grounds of some other characteristics such as disability.
In a similar vein, apart from the opposite end of the age scale, a 26-year-old claimant in Lockwood and Department of Work and Pensions, or DWP, challenged the lawfulness of an age-related supplement in the Civil Service Compensation Scheme. Ms Lockwood accepted voluntary redundancy from the DWP, having worked from the age of 18 as administrative officer with the Benefits Agency. Under the terms of the Civil Service Compensation Scheme, voluntary redundancy pay is enhanced for service over 35 and then again for service over 35. As Ms Lockwood was only 26 on taking redundancy, her redundancy pay of £11,000 was £18,000 less than it would have been had she been over 35 at the time she left, and she claimed age discrimination. And the case went all the way to the Court of Appeal, where the crucial issue was whether the difference in treatment in the voluntary redundancy scheme was justified. While the circumstances of Ms Lockwood at 26 and colleagues aged over 35 were broadly similar, the evidence from the Office of National Statistics showed that the individuals in their mid-20s had fewer financial and family obligations than those in their mid-30s, and could therefore generally be expected to react more easily and rapidly to the loss of their jobs. And greater flexibility could in turn be expected of them. Now, the Court of Appeal was satisfied on the facts that the DWP had a legitimate aim in rewarding older employees on redundancy better than younger employees, and that the redundancy scheme was a proportionate means of achieving that aim. The case serves as a reminder that any differences in treatment between employees that relate to age are likely to amount to age discrimination, including for the DWP, and hence they must be justified.
And there was a further case on retirement ages last year. I mean, you'll remember that what we call the default retirement age of 65 was scrapped some years ago. So if you do still wish to rely on a retirement age for your employees, this will be directly age discriminatory and would have to be justified. And there are only a few ways in which employers can even attempt to do this, because they first of all have to show that there is actually a public interest objective behind the retirement age that has been imposed, as well as then having to justify it in their own circumstances. Now, public interest objectives can include obvious things like workforce planning, staff retention, what's been called intergenerational fairness, and also dignity. The dignity one is the most controversial, because the idea is that you might be able to justify having a compulsory retirement age because it would avoid you having to manage older staff whose performance was deteriorating. There's a certain presumption in there which isn't necessarily fair. Anyway, in England Transport and Environment Committee of London Councils, an employment tribunal held that a parking adjudicator couldn't be forced to retire at 70. There was a decision not to renew his appointment beyond his 70th birthday. This was held to be age discriminatory because the decision that had been made had failed to actually explain why they'd chosen the age of 70. It went to the tribunal. The tribunal did accept that these public interest objectives, the ones I mentioned earlier, could conceivably apply in this case. But the committee had failed to consider other methods of assessing competency, other ways of carrying out the assessment of the appropriate retirement age. They'd just simply come to an arbitrary cut-off date or age of 70, and that was, as we all expected it would be, directly age discriminatory.